3 streets in his neighborhood. He doesn't know that as he's doing his video walkthrough, over his shoulder is the address that he claims he couldn't see. Those are not minor things. Those are evidence of someone who is intentionally obfuscating. And let me put it this way. There are 2 people involved here. One of them's dead and one of them's a liar. That is a circumstance that this court ought to consider, and it's a reason that the jury ought to consider. So between the direct evidence and the circumstantial evidence of his ill will, Your Honor, I will now go towards what the cases have to say about that. The only hypothesis of innocence, as I've said, is that the defendant was engaging in self-defense. Included in the packets that I've given, Your Honor, the second case, I believe, in order is Melehan, M-E-L-E-H-A-N, which is the 4th District Court of Appeal decision from June 6th of last year. And essentially and I believe it's on page 11 of the court's copy, the court sets out the law as it relates to this sort of motion. Moving for a judgment of acquittal, the defendant admits the facts in evidence and every conclusion favorable to the adverse party that may be fairly and reasonably inferred from the evidence. Even if this were a circumstantial evidence case, which, again, the state argues it's not. There are circumstances, but it is not a purely circumstantial case, and therefore the special burden, as it were, doesn't apply. But even in a circumstantial evidence case, the state must present evidence that conflicts with the defendant's hypothesis of innocence, but the state is not required to completely disprove it. Further, I've provided the court with the case of Sherrod, S-H-E-A-R-O-D versus State, which is the 2nd District Court of Appeal opinion 992 Southern 2nd 900. It's from 2008, and I believe I saw this in the packet Mr. O'Mara handed me too. But on page 6, I think it's page 6 of the court's copy, page 5 of the opinion. Again, the court reiterates this. Unless there is no view of the evidence which the jury might take favorable to the opposite party that can be sustained under the law, the trial court should not grant this motion. The existence of contradictory, conflicting testimony or evidence does not warrant a judgment of acquittal because the weight of the evidence and the witness's credibility are questions solely for the jury. Where there is room for a difference of opinion between reasonable men as to the proof of facts from which the ultimate fact is sought to be established, the force of such conflicting testimony should not be determined on a motion for judgment of acquittal. And finally, Your Honor, I've also provided the case of Thompson versus State, 944 Southern 2nd 546, another 4th District Court of Appeal case, this one from 2006. And beginning on page 5 of this copy, again, in the second-hand column, they talk about the generalized burden, and then they say this. When moving for judgment of acquittal based on the insufficiency of the evidence, the defendant admits not only the facts adduced in evidence, but also every conclusion favorable to the state that a jury might fairly and reasonably infer from the evidence. So, Your Honor, as to whether the state has met its burden at this stage regarding the defendant's intent and state of mind, I submit that both through direct and circumstantial evidence that has certainly been done. In fact, the only hypothesis of innocence put forward is the notion of justifiable use of deadly force, and so I'm going to move to that. I think the facts testified to by the eyewitnesses who saw the defendant and the victim struggling together, upright, and at one point a pursuit involved, coupled with the inconsistencies and the expressions about defendant's own attitude, more than create a substantial question for the jury in that regard. As to self-defense, whether or not the use of force, particularly in this case, the use of deadly force, is justified. The state has a burden to discuss here, and I'm going to refer the court to two cases in particular in this regard. And the first is Leisure versus State. That's Leasure, 105 Southern 3rd 5. That is the second DCA opinion from October of last year. Beginning on page 10, I believe, of the court's copy, under head note 3, or outline column 3, where they discuss the motion for judgment of acquittal as to self-defense. The court says this, and briefly the factual scenario is this. At trial, Leisure raised two separate arguments in support of her motion for judgment of acquittal. She asserted both of those that the defendant is asserting here, that the state failed to prove that she acted with the requisite intent, and also that the state failed to overcome her allegation of self-defense. When a defendant claims self-defense, the court said, she bears the initial burden of presenting a prima facie case of self-defense. Again, I'm going to assume for purposes of this argument that the court has satisfied the defense has done so, because if they haven't, school is out as to this already. I believe that it is a fair inference from the evidence in this case that the defendant started this, or at a very minimum that Trayvon Martin had as much right to defend himself as this defendant claims he did. But I'll get back to that notion in a minute. But where a defendant claims self-defense, the state has to rebut it, but the state has to do so in the following manner. State may present such evidence through rebuttal witnesses or by inference in its case in chief. Moving across to the next column, Leisure argued that the state failed to meet its burden because there were no eyewitnesses to contradict Leisure's testimony, and the medical evidence did not contradict her testimony. She argues that her inconsistent statements to the police were nothing more than the use of extremely poor judgment after she panicked. This is sounding exceedingly familiar. However, even when there are no other witnesses to the events besides the defendant, and in this case there weren't, even Mr. Good was long gone before the shot took place, a jury is not required to accept the defendant's testimony in support of her self-defense theory as true. Instead, it must consider the probability or improbability of the defendant's credibility in light of the circumstances established by other evidence. Numerous inconsistent statements to the 911 operator and then to the detectives cast significant doubt on her assertions that she had a reasonable fear of death or great bodily harm. So let's talk about that. I will also go on to note that on page 11 of this court's opinion, under head note 4, there is a lengthy discussion of the standard as to the judgment of acquittal for the malice or the intent prong. And the law appears to be virtually identical, but I want to draw back to one thing. The bottom of that page and moving on to the next page. Circumstantial evidence standard does not require the jury to believe the defendant's version of the facts if the state produces conflicting testimony. Even when a defendant's theory of events is not clearly contradicted by direct evidence, a judgment of acquittal is not required. A common-sense view of the circumstantial evidence might lead the jury to disbelieve the defendant's theory. They go on to cite some other cases of the same nature. And again, they cite Rasley, R-A-S-L-E-Y versus State. First, I'm going to discuss why I think that, as opposed to the Jenkins case, this case is by far more, at least in a legal sense, and certainly as it relates to the nature of the arguments, far more close. The defendant was armed, fully loaded with hollow point bullets. The victim was not. The defendant outweighs Trayvon Martin by 40 or more pounds. In fact, he even said to the detectives he didn't even think Trayvon Martin was armed. The defendant's attitude about these assholes, these guys, calls him a suspect at every opportunity. He is operating contrary to his training. He's operating contrary to the direct suggestions of the police. According to the testimony of at least some of the witnesses, the defendant initiated that confrontation. There was running, there was a chase, there was an upright struggle. The defendant was seen atop the victim by a number of people. John Good saw the victim on top of the defendant. It doesn't mean the positions didn't get switched, that there wasn't a rolling struggle, but none of that justifies granting a judgment of acquittal. The defendant is the one with the MMA training. The defendant's injuries have at a minimum, by him, been significantly exaggerated. He was caught in several inconsistent statements, and I'm sure the court has noticed some, but let me put it this way. This defendant has been now exposed as having gone weeks after this incident in the company of his attorney on a nationally televised program in front of millions of people and told a flat-out lie, a big one, about whether he even knew about the nickname for the self-defense law in the state of Florida. He's demonstrated that he has no apparent compunction about doing something like that. I'm not sure why any jury should be presumed to have to take his word about anything else. And the only person who offers any evidence that the victim in this case, who ended up with the bullet in his heart, was the initial aggressor in any way, shape, form, or fashion, is the guy who went on Sean Hannity and lied. He certainly has the knowledge or the ability or the access to the materials in the background to construct a lie if, in fact, he saw fit. This is not some rube, some guy who's never been exposed to any of this. This is a person who's been studying this for years. The physical evidence is certainly inconsistent with his hypothesis of innocence, the position of the victim's body, the absence of DNA and fingerprints, the idea that somehow he was smothered and his nose was pinched with this horrific bleeding injury, not leaving a trace anywhere. There is, of course, the matter of who was screaming. At least two people have said that's Trayvon Martin. A third has said it sounded like a boy's voice. And the defendant, of course, in his recorded statement said that doesn't sound like me. Spin that how you want to. That's what he said. And then, of course, there's the common sense matter of the fact that the scream stopped when the gunshot got fired. The physical evidence of the wound itself and the hole both through the hoodie of Trayvon Martin and through his body, or into his body, it's been sort of suggested or argued, I think, several points throughout this case that it shows that the victim was leaning over the defendant when the shot got fired. And I guess he would have everybody believe that that is a possibility. That is equally consistent with the idea that Trayvon Martin was pulling away at the time the shot got fired, and that it wasn't some Arizona iced tea can dragging his hoodie out, but it was his body pulling it back. In either event, again, certainly open to a jury question as it relates to that. It is as consistent with the victim defending himself as it is with the defendant and his version. There is